Claims arising out of a person's death are different from ordinary personal injury claims. When someone dies, there are two types of claim. The first is the estate's claim on behalf of the deceased under the Law Reform Miscellaneous Provisions Act, and the second is a claim on behalf of the dependents of the deceased in their own right under the Fatal Accidents Act. The estate must bring a claim within 3 years of the date of death or the date of knowledge of the personal representatives, and can only be brought if the deceased had a claim at the time of death. If the deceased's own claim was statute barred at the time of death, then you cannot bring a claim. The Law Reform Miscellaneous Provisions Act allows the estate to claim for pre-death pain and suffering and loss of amenity. The estate can also claim special damages from date of the injury up to the date of death, such as past losses and expenses, loss of earnings, medical expenses, care, travelling expenses, as well as funeral expenses, if paid by the estate, and probate fees. The Fatal Accident Act sets out the definition of who is a dependent and might be eligible to bring a claim against the defendant. The Act allows the dependents to claim for their loss of financial support, both in terms of the deceased's earnings and pension, as well as loss of other support and gratuitous services, such as childminding, domestic chores, DIY, gardening and home maintenance, etc., and funeral and other expenses if paid by the dependents. A bereavement award is made under the Fatal Accidents Act 1976. The bereavement award is £12,980 for deaths after the 1st of April 2013. The list is very restrictive and you are only entitled to the award if you fall into one of the following categories: a spouse or a civil partner of the deceased, where the deceased was a child who was never married or in a civil partnership, then payment to his parents if he was legitimate or his mother if he was illegitimate. It is surprising that a child who loses one or both parents is excluded by the Act, as they both fall within the category of dependents and can make a dependency claim if they can prove that they were financially dependent upon the deceased. When someone dies, there is a legal process known as probate to formally appoint someone, usually the next of kin or executor named in a will, to be the personal representative for the deceased and to deal with the estate. Where there is a will, the representative is called an executor, and a grant of probate is issued from the probate registry. Without a will, the representative is called an administrator, and the probate registry issues a grant of letters of administration. It is the grant of probate or grant of letters of administration that provides the legal authority to deal with all aspects of the deceased estate, and this includes being able to pursue a claim or litigation on behalf of the deceased.